In this third session on peaceful settlement of disputes, we address diplomatic mechanisms that are the most frequently used in international relations. We are going to explore mediation, good offices, inquiry, and conciliation through the lenses of specific disputes between Georgia and Russia, the Gambia and Myanmar, Turkey and Israel, Bolivia and Peru, among others. We will also examine how prominent figures in international relations, such as the Pope, the King of Saudi Arabia, or the former President of Ireland, have played an important role in mediating international disputes. Remember the principle of freedom of choice, so states can decide whatever mechanisms will help them resolve their dispute. In this session, as most textbooks of international law, we are going to follow on the ones listed here: negotiation, good offices, mediation, conciliation, and inquiry, because they are the ones which are listed in Article 33 of the United Nations Charter and the Manila Declaration, to which we referred to in our first video on settlement of disputes. They are also listed in the 1970 Declaration on Principles of International Law concerning friendly relations and cooperation among states, among other documents. It is important to underline, however, that this is not an exhaustive list. States can use other mechanisms that are not contemplated here. For instance, they can decide to resolve the dispute or to use one of the means of resolving a dispute confidence building techniques such as joint military exercises. I will come back to other different ways of approaching a dispute and enforcement of international law when I deliver the lecture on enforcement of international law. All diplomatic means of settling disputes share the characteristics explained in our second session, so I will not get back to this. Within the different diplomatic means of resolving disputes, the differences are mainly related to the level of intervention of a third party in resolving the dispute and whether or not the process is more or less regulated. So from less intervention to more intervention, from less regulations to more regulations, we have here listed negotiation, good offices, mediation, inquiry, and conciliation. No third party is involved in negotiations, but a third party with an increased role in resolving the dispute is involved in all the other mechanisms that we have chosen to explain here. Let's see this through specific case studies. Negotiation involves full flexibility and no third party involvement, which is normally the system or the mechanism states will resort to as the first step to resolve their dispute. So it's the most widely used mechanism, is compatible with any other form of resolving disputes. This means if states are trying to resolve a dispute before the International Court of Justice or through conciliation, through mediation, they can also, parallel to that, always negotiate their dispute directly. Because no third party is involved, is also particularly prone to great inequality between the states parties to a dispute. There's nothing to mitigate the difference in power in a negotiation between, let's say, the US and Vanuatu. As we will see, there is no obligation to negotiate unless another source of international law imposes it. As covered in our former video, the International Court of Justice clarified the meaning of dispute in its 2011 judgment on the case of Georgia versus Russia. In that context, the court also took the opportunity to expand on what constitutes negotiation, establishing that negotiations require some level of engagement that goes beyond the mere protest or opposition of legal views. Therefore, negotiations can not only constitute an exchange of views or information to assess the position of the parties in the dispute. In other words, negotiations are different from the dispute. To establish a dispute, it is enough to determine that two or more parties have opposing views. However, to establish that negotiations have existed, it is necessary that the parties have engaged in a dialogue with the intention of resolving the dispute beyond asserting that they are actually in a dispute and that they have different positions. As I just said, there is no obligation to negotiate unless a treaty, a judgment binding to the parties in the dispute, or a decision of the Security Council provides otherwise. This is pretty much true from about any other means of settlement of disputes. So theoretically, it is possible that a treaty, a judgment, or the Security Council oblige the parties to a dispute to enter good offices, mediations, conciliation, or any other means of settling dispute. However, when this happens, it is much more frequent to find it for the case of negotiations. For instance, we find the obligation to enter negotiations or an exchange of views in the language of Article 283 of the United Nations Convention on the Law of the Sea. So this will be an example where the parties to a dispute are obliged to negotiate because a treaty to which they are parties establishes it. On this slide, I have reproduced the Security Council resolution of 1976 compelling the Greek and Turkish government to resume negotiations in relation to their dispute over the delimitation of the continental shelf on the Aegean Sea. So this is an example of the Security Council, of a Security Council decision that is binding to the parties and that calls upon them to start negotiations. The International Court of Justice can redirect parties to negotiate when there is a basis for such obligation. I have reproduced a paragraph in this direction, and it's an extract from the sentence issued by the International Court of Justice on the Gabčíkovo-Nagimaros project case. In issuing this kind of judgment, the judgment itself obliges the parties to negotiate in addition to whatever other original obligation on which the decision of the court is based. To recap, the general principle remains that except explicit obligations to the contrary, states are free to choose which settlement of dispute mechanism they want to pursue. This has been clarified further in a dispute between Bolivia and Chile that was resolved by the International Court of Justice in two judgments issued in 2015 and 2018. The subject matter of the dispute was precisely a dispute about the existence of an obligation to negotiate. In particular, the court framed the dispute as consisting on whether Chile was obligated to negotiate in good faith Bolivia's sovereign access to the Pacific Ocean, and if such an obligation existed, whether Chile had breached it. In its final judgment on merits, especially its paragraph 91, issued in 2018, the International Court of Justice reaffirmed that the obligation to negotiate is like any other obligation of international law and must find its basis on the usual sources of international law. In this particular case, the court could not find sufficient basis to establish the existence of an obligation for Chile to negotiate. Every other settlement of dispute mechanism involves a third party. We are going to start exploring them, starting with good offices and mediations. As explained earlier, these are technically different roles, with the good officers facilitating the negotiations rather than being part of them, but in practice the dividing line between roles is not always clear. Both good offices and mediation are often used as synonyms. The third party used by the state who resort to good offices and mediation is typically a trustworthy figure who is chosen precisely because the parties in the dispute trust on this person and because they trust on their diplomatic skills and their general caliber. They are not chosen normally because they are experts in the area of the disputes or because of their knowledge in international law. Therefore, it is frequent that those involved as third parties are state representatives or other representatives that we find as normal operators in international relations, such as diplomatic agents or ministers of foreign affairs. Remember that equality between parties is never guaranteed in the context of diplomatic means, and the solution might well be influenced by who is the most powerful state party in the dispute. Religious leaders have a long tradition in intervening in international disputes as mediators or good officers. It has been suggested that religious leaders may be better suited to resolve a dispute such as the conflict between Pakistan and India over Kashmir, because other secular approaches ignore the religious elements that are actually influencing the dispute. The Catholic Pope and the Vatican City, represented through other agents, have been involved as mediators in multiple conflicts. For instance, Pope John Paul II mediated a dispute between Argentina and Chile in 1984 over the title to territory to several islands that were rich in oil. These were the islands of Picton, Lennox, and Nueva that are illustrated in the map that I have included here. The dispute concerned the Beagle Channel separating Argentina and Chile. Depending on what line was considered as the route of that channel, these islands will belong to Argentina or Chile. I hope you can see my slides properly here, so if I use a pen, just wait a second, I'm going to use the laser pointer. So this is the area of the dispute in the Patagonia, in the south of Argentina and Chile, and here in the south, as a border between both countries, you have the channel, the Beagle Channel. Okay, I have reproduced it here bigger, and you can see a red line, that one, a yellow line, and a blue line. So depending how you draw as a border, how you understand the course of this channel, these islands become part of Argentina or become part of Chile. And this was the main object of the dispute. The choice of what mechanisms to choose to resolve the dispute once the negotiations failed was in itself a dispute. The Argentinians wanted to use the International Court of Justice, and the Chileans desired an arbitration procedure led by the British Crown. A very original compromise was reached that involved everything: arbitration, the Queen, and the International Court of Justice. In 1971, Argentina and Chile signed an agreement by which they designated an arbitral court composed of 5 members of the International Court of Justice. In other words, the arbitrators were also serving judges of the International Court of Justice. The arbitral court was entrusted with deciding the merits of the case, and then they had to transmit the decision to the British Crown. So the arbitrators were in charge of providing a solution, but that solution in itself was not binding. It had to be sent to the Queen, who was the one who had to accept or reject the final decision, but couldn't modify it. To recap, the parties decided to submit the dispute to arbitration under the auspices of the British Queen, using judges of the International Court of Justice as arbitrators. This arbitral process took almost 6 years, with the Queen at the end of it accepting the arbitral award, by which Chile mainly won this case. Rather than resolving the conflict, the award fueled the hostilities between Argentina and Chile, almost leading to an armed conflict between the two countries. In fact, Chile supported the UK when the war between Argentina and the UK started over the Falkland Islands. As you can see, the Falkland Islands, called the Malvinas by the Argentinians, are also relatively close to the Beagle Channel. I have used a blue circle to point out where the Falkland, the Malvinas Islands are on the map. During this time, both Argentina and Chile were also governed by military governments which was another factor facilitating a tendency to escalate a bellicose, warlike approach. In this environment, the Catholic Church started a peace campaign within both countries that included marches to the Andes, the mountains, youth movements, and petitions that culminated with the intervention of the Vatican City through the Pope John Paul II. Only the papal mediation put an end to the dispute dividing the islands between the two countries. So, it was the leader of the Roman Catholic Church, the only party to which the military governments of Chile and Argentina could at the end defer without losing face. This is the typical example where a legal settlement of a dispute with a clear winner and loser is less effective than a more political approach to resolving the conflict through a compromise between the parties, using, in this case, the mediation that both parties trusted. In the words of Lisa Lindsay, a century-long conflict was resolved when domestic political changes, a skillful mediation, and a willingness to compromise converged. Another example of the so-called faith-based mediation can be found in the important contributions of the Interreligious Council of Sierra Leone in the peace process that followed the civil war in that country. Many other examples of mediation and good offices led by head of states and other senior officials on which the parties of a dispute trust can be found. The leverage and prestige of the good officer is fundamental to reach a final agreement. Throughout the course, I have also used several times the example of the conflict between Qatar versus Bahrain to explain different topics, such as the definition of treaty. This dispute also offers a good illustration of a provision of good offices, in this case provided by the King of Saudi Arabia. The Beagle Channel dispute was resolved by attempting several forms of third-party interventions. The third-party mediating can take many shapes. For instance, in the Israel-Palestinian crisis, the so-called quartet was put together in 2002. This quartet was composed by the United States, the European Union, Russia, and the United Nations. In 2003, the quartet released its performance-based roadmap to a permanent two-state solution to the Israeli-Palestinian crisis. As we can see here, the mediator does much more than facilitating a dialogue, negotiations between the parties in a dispute. It suggests a specific solution, in this case named the roadmap, that was originally drafted by the US State Department based on a speech President Bush gave in June 2002, and that laid out a vision of Israeli and Palestinian states living in peace. It was then modified and endorsed by the quartet. The UN Secretary General has provided good offices of mediation in a wide range of disputes. This role has been at times questioned on the basis that it contradicts the impartiality of the Secretariat as prescribed in Article 100 of the UN Charter. In practice, this has not had an impact, and the Secretary General in person or through its envoys continues to perform that role. In 2017, the current Secretary General, Antonio Guterres, published a report with his strategy to support mediation. This included promoting the role of women who have been seriously underrepresented in the role of mediators or providers of good officers. To give you an idea, available data reveals that out of a total of 31 UN-led mediation processes between 1991 and 2011, only 3 were led by women as the chief mediator. In order to reduce the underrepresentation of women, 2 female led mediators were appointed in 2014. The former Irish President Mary Robinson and Hirut Gebre Selassie of Ethiopia. The situation remains really poor. Anyway, over the different lectures, we have also seen quite a few examples already of the role of the Secretary General and his envoys in mediating disputes. For instance, in the analysis of the Western Sahara case, we have seen how the latest attempt to resolve the conflict was mediated by the UN Special Envoy John Baker, who resigned when he reached the conclusion that no solution would ever be agreed by Morocco and Western Sahara, a solution satisfactory for both sides. This is another typical example of mediation where the third party not only tries to facilitate the dialogue but also suggests possible solutions. Similarly, when examining international responsibility of states, we used as leading case the Rainbow Warrior case, where the UN Secretary General acted as arbitrator. So, as we can see, the role of the UN Secretary General is particularly relevant in mediating international disputes between states. Inquiry or fact-finding mechanisms engage a third party to make a determination over disputed facts. This mechanism may be enough as a means of resolving a dispute if the dispute's main object is precisely a disagreement over what happened. However, this is hardly ever the case. Most frequently, the inquiry is part of a wider range of tools to resolve an international dispute. For instance, a tribunal may need to assert the facts before entering to assess the legal elements of the case. Sometimes the adjudicating mechanism carries out its own inquiry or it relies on an external mechanism. Let's illustrate it with real scenarios from state practice. I have chosen the dispute between Turkey and Israel over the boarding of a Turkish boat by Israeli forces. On 31st May 2010, 10 Turkish nationals were killed by Israeli armed forces who boarded the ship called Mavi Marmara, operating under Turkish flag. This boat was one of 6 ships that were trying to provide aid to the population in Gaza, breaching the Israeli blockade that was in force at the time. Several facts were disputed, in particular who started the violence, with each party claiming the other started first. The Security Council intervened immediately after the incident, requesting the release of ships and crew held by Israel and demanding a full investigation. I have reproduced here 2 paragraphs of the statement issued in this regard by the President of the Security Council. In September 2011, the UN inquiry on the dispute, led by a panel of 4 persons appointed by the Secretary General, all male, concluded that both parties exercised violence. On one side, the Israeli Defense Forces were faced with organized violence when they boarded the Mavi Marmara, and they were compelled to protect themselves by using force. However, the inquiry could not find enough justification for the killing of some passengers or for the serious injuries that were suffered by others, particularly because forensic evidence revealed that the people who were killed were shot multiple times in the back or at a close range. The inquiry did not resolve the dispute. The tensions between Israel and Turkey escalated to the point of cutting diplomatic relations. It was the good offices of US President Obama what allegedly led to a telephone conversation between the prime ministers of both countries in 2013, and that started the normalization of relationships between Turkey and Israel. So finally, the parties resolved the issue via negotiation and agree that Israel will apologize as well as provide the compensation. On the other hand, Turkey agreed to pass legislation protecting Israeli troops from legal claims. So all this also relates to what we have seen about reparations in the topic of when exploring the topic of international responsibility. In the dispute between Hungary and Slovakia over the Gachekovo-Nagy-Maros project, the European communities acted as mediators. As a result of that mediation, the parties agreed to create a committee of 3 experts to conduct a fact-finding mission to establish the effects of Variant C that was built by Slovakia, and they also agreed to take their case to the International Court of Justice. On that occasion, The fact-finding mission also had to submit suggestions for emergency measures to be adopted in order to prevent further damages. The findings and recommendations of the fact-finding mission were referred to the International Court of Justice. In addition, the International Court of Justice also carried out its first ever visit to the site to acquire a direct understanding of the situation. Therefore, several mechanisms were used successively or simultaneously: mediation by international organizations, the European communities, the International Court of Justice, and fact-finding missions carried out outside and inside the context of judicial proceedings. Fact-finding mechanisms are widely used by human rights bodies, where they normally try to ascertain the facts about alleged human rights abuses, many times involving on-site visits, determine the possible existence of a state responsibility, and 3, make recommendations on how to seize the violations and provide reparations. However, as we can see here in the Kachikovo-Nagimaros project case, fact-finding missions are also part of a wide range of other kinds of disputes. In the videos recorded by Professor Shebas on the Gambia versus Myanmar case, he also alludes to the relevance of a UN fact-finding mission as a precursor of the proceedings before the International Court of Justice. It is not clear at the time of recording this video if the findings of that mission will also be relevant in determining the final outcome. A state party to a dispute may decide to set up a body of experts, normally called a commission, composed of independent experts acting on the basis of impartiality. The final outcome is not binding to the parties, and this means of settling disputes is called conciliation. Conciliation is categorized as a political mechanism of resolving disputes because the final decision is not binding. And the main objective of the third-party intervention is to find a compromise between the state parties to the dispute, rather than a final solution based in law. However, this means of resolving disputes shares many similarities with arbitration and judicial adjudication. The configuration of the Commission and the functions of its members is regulated according to international law. In summary, the main purpose of conciliation is to lead the parties to reach an amicable settlement of their dispute. The role of the third party is not to settle a dispute by applying law per se, but rather to bring the parties to an agreement by way of negotiation and compromise. In practice, conciliation is not widely used, but it appears in a wide range of in many treaties, including Article 33 of the UN Charter. A relatively recent case of conciliation to resolve a maritime boundary dispute between Timor, Leste and Australia through conciliation gives an example of the advantages and disadvantages of using this kind of settlement of dispute mechanism. When we study international law of the sea, we will cover the regime contained in the 1982 UN Convention on the Law of the Sea that includes a comprehensive settlement agreement for the resolution of disputes between state parties to that convention. At the core of this regime is the Tribunal on the Law of the Sea, a body created by the convention. The convention allows multiple choices to the parties to a dispute concerning its application, including judicial proceedings before the International Court of Justice, the International Tribunal on the Law of the Sea, arbitration, and conciliation. In 2016, and on the basis of Article 298 of the Convention, for the first time in its history, conciliation proceedings were started by Timor-Leste as a mechanism to resolve a maritime boundary dispute with Australia. The outcome of this conciliation were public, which is not the norm, since the outcomes of conciliations are usually confidential, as it is typical for every political means of resolving disputes. This conciliation ended in a final agreement in May 2018 that, as I said, was made public, and the successful resolution of this complex conflict through conciliation offers a good example of the possible benefits of using this mixed breed mechanism to resolve disputes. One of the experts acting as conciliators, Donald McRae, has recorded a short video that is available on the UN Audiovisual Library about the case, and he highlights the reasons for its success. You may want to watch to learn more about this particular case.